Each year, Congress authorizes the budget of the Department of Defense through a National Defense Authorization Act. As you just heard from Commander Palmer, they approved his atomic museum with this act. The NDAA of 2012, however, is unlike any of the previous ones. This year's legislation contains highly controversial provisions that empower the armed forces to engage in civilian law enforcement and to selectively suspend due process and habeas corpus, as well as other rights guaranteed by the Fifth and Sixth Amendments to the U.S. Constitution, for terror suspects apprehended on U.S. soil. The final version of the bill passed the House on December 14th. The Senate the following day. Ironically, it was the 220th birthday of the Bill of Rights. It was signed into law by President Obama on New Year's Eve. With his signature, for the first time since the Internal Security Act of 1950 and the very dark days of the McCarthy era that followed, our government has codified the power of the indefinite detention into law. This law can be used by authorities to detain forever anyone the government considers a threat to national security and stability, potentially even demonstrators and protesters exercising their First Amendment rights. Now, while the law does not explicitly target U.S. persons, it neither excludes nor protects them, and hence the problem. Now, throughout the night, we are going to be bringing you special guests here on Coast to Coast. This first half hour, Jonathan Emord, constitutional lawyer, joins us. In the second half hour, David Seaman joins us, independent journalist, frequent contributor to many major news organizations. Tyrell Ventura, the son of Jesse Ventura, joins us next hour, as well as Gerald Salente. And then in our final hour, Alex Jones joins us, plus we'll take phone calls with him. For the first couple hours, co-anchoring this program with me tonight will be none other than Linda Moulton Howe, of course, our award-winning reporter. Linda, how are you?
Well, thank you. And, George, I could not agree with you more about how unnecessary and dangerous the wording in this 2012 National Defense Authorization Act is, especially after talking with a Harvard professor of law and to the senior legal analyst at the ACLU.
Linda will have a very special report on this as well during her monthly segment next week on Coast to Coast AM. She's got some great stories for you, but included in those stories, she is highlighting this National Defense Authorization Act. So Linda and I will be back in a moment with Jonathan Emord as we begin this special report on the NDAA. Is it unconstitutional? That's next on Coast to Coast AM. And welcome back to Coast. I'm George Norrie, and our very first guest tonight as we talk about the National Defense Authorization Act. Linda Moulton Howe is with me, is Jonathan Emord, principal of Emord and Associates, practicing constitutional and administrative law in Washington, D.C. He is the only attorney in history that has defeated the Food and Drug Administration several times in federal court on First Amendment grounds, and here he is. Jonathan, I don't think you've ever met Linda, have you?
I don't think we have.
Well, there you go. Say hello.
Nice to meet you.
Pleased to meet you.
Jonathan, I want to get your take as we continue this discussion with you this half hour on this act, the NDAA, as we will call it tonight. A lot of people are concerned that it is not going to be constitutional, that our rights will be eroded. You are an expert. You are a lawyer. What do you think?
I believe it is unconstitutional. And, in Article 1, Section 9 of the Constitution, Clause 2, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. This has been interpreted to mean that your right to access a court when you are detained may not be encumbered or blocked by the state unless it is in the theater of war, unless there is active open rebellion, whether civil war in the United States or overseas. This act would allow an American citizen on a charge, unsubstantiated substantiated charge before a court, a charge that they substantially supported a terrorist organization or terrorist, to be rounded up by the United States military and incarcerated indefinitely, that is until the end of a formal declaration of the end of the war on terror, which will never likely happen, and to be denied the right under the Fifth Amendment of due process, under the Sixth Amendment to a speedy trial, to a trial by jury, to be informed of the precise charges against you, to confront the witnesses against you, to subpoena witnesses in your defense, and to the assistance of counsel. In other words, you will be thrown in jail as if you were being taken by an absolute monarch or king and ordered into the dungeon.
Forever?
Forever.
Now,
you know, this is not unprecedented, George, unfortunately.
You know, we don't have people like Joseph McCarthy running around, I don't think. But, I mean, if we do, Jonathan, if we get someone who says there's a communist at every corner, or these people are bad, or so-and-so's a terrorist, what kind of dangers, then, do we have with this thing as law?
Well, this thing, you know, it's been our history since English precedent from Lord Coke when the writ of habeas corpus was first created. It's been the history of civilization that when a power is vested in government that is absolute like this, to take a person and incarcerate them and to throw the key away, that it is always abused in the sense that a person is charged and is not given a fair hearing and is condemned. We've seen this in recent history with capital punishment. People have wrongly been accused of murder, have been incarcerated, and they've thrown the key away. Well, at least there was a judicial check so that it didn't happen all the time, as horrible as that is. Without that judicial check, when things happen in secret, when a person can be taken at night and thrown into a military prison and left there with no further notice to anyone, that is the end of liberty.
Linda, what was it about the NDAA that caught your eye?
Well, one of the surprises to me in interviewing the senior legal analyst counsel for the American Civil Liberties Union in Washington and talking with Professor Mark Tushnet at Harvard Law School, I wanted to know, one, who has control on this, we'll say, the terrorist alert, and is it clear in this new NDAA whether an American citizen is immediately going to continue to have rights within the American legal system, or will a military authority take over? And here is the surprise. And this is a quote from Christopher Anders, the senior legislative counsel at the ACLU in Washington. Presumably, it is the Defense Department who will control the execution of this wording in the National Defense Authorization Act. But, quote, one of the things that is amazing about this is that the NDAA does not actually say who is making the decision.
Jeez.
It says that the president has this authority, but it does not say if it is the president alone that makes this decision. Is it people in the military itself? Is it civilians in the military? Is it a government bureaucrat somewhere, close quote, all of which leaves an extremely dangerous, murky, ambiguous mist in this NDAA. And then when it comes to you, I, any one of us on the street, if somebody from DOD who is assigned to come and say, we suspect that you are a terrorist, they can take you away. And the unanswered question right now is, would an American citizen automatically remain in the American legal system, or would it transfer into a different track of military authority that happened to Jose Padilla back in 2002? An American citizen arrested, taken into military authority for 5 years without charge.
Jonathan, this act, which comes up every year, Who leaked this part of the provision in it? How did that get passed through everybody, Republicans and Democrats?
Well, the sponsors of the bill, Carl Levin and John McCain, put this language into the bill, and Rand Paul authored an amendment to the bill that would have stricken it, but it didn't pass. And the bill passed, with overwhelming majorities in the House and the Senate. And so the president, who objected to this provision, interestingly enough, signed the bill nonetheless because he wished to have the other aspects of the bill in place, and said that he would police it so as to not allow these civil liberties violations to take place. But the point is, the law itself is unconstitutional. The ambiguity as to whether or not this is going to be undertaken against American citizens domestically, or whether it's only in the theater of war, is one that is unacceptable. When you have a law that will allow the incarceration, will allow criminal sanction to be invoked, and suspension of the writ of habeas corpus, you must have precise language, or it is unconstitutional. And the precedent here is for the President of the United States to take action directly or to delegate that authority to military people. That's what Abraham Lincoln did when he suspended the writ of habeas corpus unconstitutionally. Only Congress, under Article 1, Section 9, can do that. Congress has done this here without invoking Article 1, Section 9, but nonetheless, the effect of this is to suspend the writ of habeas corpus. And the precedent for the executive department, which will have control over this, is for the president to use it or to delegate it to military leaders to do it. And this is a law now in place that will have an effect not just in this administration, but in subsequent administrations.
And is it good for just 1 year, or is it going to roll over?
Well, the provision is going to be in place here until Congress removes it. And I'm afraid, unfortunately, that this thing is going to be around for a while unless we rise up and do something. There won't be a justiciable case or controversy under this until someone's arrested.
That is exactly what the ACLU said, that this is now in one of those strange zones where it is as if this authorization has gone forward and is now a statute of law with code, and that none of us will know exactly how this is going to break out until somebody is arrested under it, and then there's going to have to be a challenge in the courts. And as the ACLU counsel pointed out, if it took 5 years for there to be any kind of court action on Padilla between 2002 and 2007, what would happen to an American citizen if they are arrested under this NDAA and that they are, we'll call it deflected into the military side under authority, and someone tries to hold them without charge and there is no legal proceeding? It means that the ACLU and any other bodies would have to challenge this and try to take it to the Supreme Court if Congress doesn't rescind it. Sir, is that your understanding, that we're now in a kind of strange holding pattern, waiting for an arrest to see what the courts can do to straighten this out?
Well, that's right. And, the provisions of this law talk about it as indefinite. I mean, you have the detention under Section 1021C1, detention under the law of war without trial until the end of the hostilities authorized by the Authorization for Use of Military Force Act. So,
well, there will never be any end of hostilities under Homeland Security and the threat of terrorism, quote unquote, Jonathan. It'll go on forever.
There would have to be a declaration that there was such an end, and that's unlikely.
And Congress, as the ACLU is saying, the quote, Congress has made a mess of this, and Congress needs to clean it up. And I'm very interested, sir, if you have a perception on why it is that the Senate Armed Services Committee held secret markups on this bill behind closed doors. No one was even allowed in the room. And then it was redrafted in a conference committee. It was again behind closed doors. And that what came out of all of that? These were all secret